Hi, guys. Welcome to Parawomenradio. I'm Amy. Tonight, Suitcase Sarah has been quite the busy bee. Sarah Boone, the woman who thought it would be a great idea to zip her boyfriend up in a suitcase and refuse to let him out, which didn't exactly have a very happy ending for the boyfriend. Yeah, that woman. Well, after a 58-page letter she penned to the court, the judge finally put the boot down and said, "Eight is enough for you, little missy. No more lawyers." Sarah Boone is now representing herself because we all know how well that usually goes for people, right? Also, it was reported to me that Sarah Boone had a GoFundMe page that went up and then promptly back down a few hours later. And we have some receipts on that one. And finally, we're going to take the epic 58-page letter dive that she wrote to court. I got my reading glasses handy because we're all about to wade through all the drama and more. I bet by the time this live is over, she'll have been up to even more shenanigans. I don't know. Who knows with Sarah Boone? While we wait for the others to roll in, a shout out to my replay crew and my dragonflies. It's July 3rd in the United States, 2024. Be safe wherever you are. Play nice with the fireworks. And whenever you are watching this, I hope you're well. Guys, welcome to Parawomenradio. I'm Amy.
Here where my soul bleeds openly, deep in the
Hi, guys. Welcome to Parawomenradio. I'm Amy.
here where my soul bleeds.
Guys, welcome to Parawomenradio. I'm Amy.
Here where my soul bleeds openly, deep in the heart of sin and you. Here in the blue, I'm falling deep into you. Here in the blue, I'm dancing with you tonight, and it feels fine. Carefully strumming this old guitar again, words rolling out into our fire. If heaven had wings, I'd steal them and fly away with you for a while. Here in the essence of gratitude, your dreamy little smile on my lips. I miss my cue, but baby, I had you. Miss my cue, but I had you for that day. Here in the blue, I'm falling.
Here in the blue, I am falling for all of you, but not Sarah Boone, not Suitcase Sarah. I've been doing my research on Suitcase Sarah Blame Boone all day long, and I have her voice in my head and her words in my soul. I swear. No, I'm just being dramatic like Sarah. I also rearranged my layouts and had a bit of an issue before I went live. I'm sorry. I'm so sorry, guys. Oh, main chick, thank you so much. Main chick Carrie. I really appreciate that. And we love you so much. Main chick Carrie is a dragonfly. If you don't know what that is our membership group on YouTube. Today we're coming to you over on YouTube, Facebook, and X. Hi guys, and hi to my replay crew. But over on YouTube, we have a membership program and we call ourselves the Dragonflies. I release all my videos early to the Dragonflies. They have special emojis. We have a group chat, or not a group chat, once a month live chat that we do together. We could have a group chat over on Facebook. I've been thinking about it. I've been thinking about what we can do to create a space so that the Dragonflies can hang out and chat. Been thinking Facebook or Instagram or both. But yeah. And so speaking of Facebook, I am looking for somebody who I've got my 2 chat mods over on YouTube. I'm looking for a mod to hang out in Facebook because we do go live over on Facebook, and someone to help me run the Facebook group and all that good stuff. If you're interested in anything like that, I just jumped right into something I was going to do at the end, but sorry. Parawomenradio@gmail.com is the email if you're interested. But yeah, the Dragonflies, getting back to the Dragonflies, we have a drawing that we do. We have a Dragonfly of the Month. And it's just a way for, if you like the channel, to one, support the channel, and to get to know us better. But you don't have to do all that to get to know me. You can just email me anytime you want. I respond to messages, but messages they're picking up. So I'm getting a little behind on the messages, I think, or the messages on the videos. I think there's going to come a day where I might not be able to hit all my messages, but I do try. And so, yeah, if you would like to join us over and become a Dragonfly over on YouTube, it's $2.99 a month. It's always going to be $2.99 a month. I'll never change it. I'll add to it, but I'll never change it. The price. All right, let's get into it. Let's get into our little Suitcase Sarah. Oh, before we start, if we could just start that algorithm dance party, just start warming up your fingers and dancing them up to the hearts and thumbs up button. It helps us dance out in the algorithm party out there, bring more people back to the party. It's just a free way to help me out, and it's really, really appreciated. All right, now let's get into it for real. Okay. So, as you know, in my last live that I did, I had a lot of problems reading her letter. And I think her handwriting is just really hard to read when it's single spaced. I mean, that's number one. But I think the number two was that it was black writing on this stark white. So I played with the color, and I'm going to see if I'm able to read it a little bit better. But I do want to give you a refresher on who and what we're talking about dealing with. Let me get my page ready. Okay. Masterpiece truly takes the cake. For those that may not remember Sarah Boone, she is the infamous Florida woman who thought it would be a fun idea to zip her boyfriend up in a game of hide and seek. However, her idea of fun quickly turned into a nightmare.
For everything you've done to me.
Sarah.
You.
Sarah.
She refused to let him out. To top it off, she decided to film herself mocking him while he was trapped, slurring her words in a drunken stupor, Unsurprisingly, Sarah then proceeded to pass out, only to wake up the next morning and discover her boyfriend no longer among the living. And that's who we're dealing with. And yes, Chris C., her handwriting is intense at times, just as intense as she is all the time. So it would make sense she has intense handwriting. Okay, so we are going to read the letter, but we're going to read that at the end because new stuff has happened. After the letter, said letter, well, actually, you know what? Let's just do the letter. What do you want me to read the letter, or do you want to give me do you want me to give you the updates since the letter? Let me go into chat and say hi to everybody, and then we can figure it out. Yeah, rest in peace, Jorge, for sure, or George. Most people call him George, but I'm sure his family calls him Jorge. Jorge. Yeah, her handwriting probably does match her moods. All right, well, let's just do this. Let's go ahead and read the letter. Because I'm feeling good. I'm feeling like my eyes are mentally ready for this. We'll see, though. I can do this. All right. Whoop. Oh, wait. You know what I'm going to do first before I feel like I can do this? I'm going to remove this, number one, and I'm going to quickly slow down the playback. This is over on my Canva account. I didn't even bother downloading it because I'm like, why? Why bother? Okay. All right, here we go. Hand delivered June 7th, 2024, Sarah Boone. And then she directed it to the Honorable Judge Michael Kranick. And then she addressed it. And she put the address and all that good stuff on there. This is the first part of it. 58 pages. She made sure to let them know in advance that she was dropping off a little 58-page note. Okay. Honorable Judge Kranick, why ongoing 5 years? Why can't I use any constitutional rights? Am I the only one who cares about the ongoing violations of have a bond, have all my medical records, have all my digital evidence and discovery, have all my paperwork, notes, letters, pictures, everything of mine returned? I didn't even check to make sure. Yeah, you can see what I'm doing. Okay. By former attorney, speak to my investigator, have a completed download of my phone, have any of my witness list, give any insights, understanding, clarification, truths about the case, especially to my attorney, be listened to by anyone, especially my attorney, be respected for who I can truly be respected for who I can truly, especially be by new attorney, and not be disrespected for the I don't know what that word is. Something miscellaneous schmurder. All the world has falsely, incorrectly created and believed me to be. Well, Sarah, no, I'm not going to interrupt. Uh, be treated fairly, lawfully, and protected by the justice system, properly, rightfully, completes, defends myself, see all, and know the same as the world can and does, including my attorney, from all the phenomenal, non permissive amount of my entire case being available online globally before my trial, and most important, before I have seen myself. Okay, well, I am going to interrupt to this. Sarah Boone, you live in Florida. Florida releases everything. I mean, this is why we see Florida woman, Florida man cases all the time, because they just vomit it out, and they have to put it up. Anything you send to them, they have to put up. They have to, do the little file, the little copy, and put it up to the system so we can see it. If you would stop writing these letters, which I'm sure, well, I'm positive now that we know the judge was like, I keep trying to say George, now that the judge says no more. Eight is enough for you, lady. So anyway, let's get back into that. Before my trial, and most important, before I have seen myself, what does anyone, and if the judge didn't release it, because he has to release it by law, that would be a problem for you too. Oh, anyway. Oops, I might get the little bird up. I gotta whisper. Or not get so mad with Sarah Boone. What doesn't anyone know already about my case? How about my side and everything? Well, how about your side? I can't stop myself. Sarah Boone, you've been sitting in there for 4 years with all the... Okay. Whew. I'm not going to do that anymore. What doesn't... I'm not the only one in doing this. Even it's very easy to start reading this in a snotty tone. And I've had people be like, you don't really need to do that. Do we need to have the voice? And I have found in every single person that is reading this, including, I just saw Dreading Crime and Psychology. They just dropped Sarah Boone's 58-page breakdown about 6 or 7. I think the bird's up. Hold on. No, I'm just hearing something. 6 or 7 hours ago, and listen to him read it.
Just altogether mean people can use their quote-unquote freedom of speech, not knowing me in any way, other than what's being said by all the other mean people.
Do you hear a tone? It's very easy to get into that tone reading Sarah Boone's stuff. Very easy. Okay, anyway, getting back to it. How about my side and everything about everything? Be correctly understood that I am not the problem for reasons I am on something appointed by the court attorney number 8. See my letter 7/21/23. Say what I want and should, but all the world can, and say it all wrong and warped. Why won't my attorney give me an honest answer? Show me everything she says she has and finished reviewing for my case, but withholds from me after I asked repeatedly for and about. Give me an answer other than I'm putting them to rest. That's not necessary, or I'm not having this conversation with you. Grant me access to anything I ask for in and about my case. Like the detectives in my case, stop putting words in my mouth. Tell me what's going on in my case. It's been well over 100 days. She has been my attorney, and I still do not know ongoing 5 years. This is some ongoing thing. Sarah just repeats herself. She just repeats herself until she gets the answer she wants. And when she doesn't get the answer she wants, she just repeats the questions. Answer any of my questions. They've been answered, Sarah. Ever you ask me any questions, how can she supposedly know everything she needs to know from what she's been told, heard, read, seen? Reassure she's on my side for me, not against. Why have I already been judged in the court of public opinion? I don't know, Sarah. How did that happen? I don't know, Sarah. I know, Sarah. We've every person that's covering this case has told you. Why have I been sentenced by anticipation and condemned before predicted trial? Why does my attorney and all the world think my case is already over? Sarah. Your Honor, during our first introduction at my last withdrawal of court appointed attorney number 7, Hobson, the buffoon, you stated to me she didn't put buffoon, I added that, your uninvolvement with any of my letters I write. You stated to me your uninvolvement with any of my letters I write. I am still going to write my letters. Of course you are. As conduently, they are, what is that? What is that word? I don't know what that word is. They are to the world. Is it comedic? It's probably comedic. As comedic? No, it's not comedic, but it is comedic. As they are to the world where all my potential jurors are located. And this is the only way anyone, including yourself, knows the very necessary insights. Oh, it's thundering out. That's what it is. It's not the little bird. I swear to God, he was such a, I swear to Zod, he was such a monster today. Ugh. But it's just thunder. To my continued disadvantages, hindrances in, I don't know, hindrances in something I am still experiencing on top of the new spurring my intentions to write the race to the pulpit is unfair. To the pulpit is unfair. And it is important to me that you are aware and understand what transpires when the new news cameras are off and we're all in between my status hearings. Yes, because everybody's life just stops while they're in between your status hearings, Sarah. As so many of the advantages, embezzlers, racketeers, as too many of the advantages, embezzlers, racketeers, something money lenders, lemmings, and just something altogether mean people can use their freedom of speech, not knowing me in any way other than what's being said by the other mean people and being said incredibly incorrectly. So can I. Well, Sarah Boone, you strike me as one of the mean people. You strike me as one of the mean people. I'm just saying, you strike me as a mean person. But Okay. As the compelling, annoyed detectives in, she calls them compelling? As the compelling, annoyed detectives in my case, uh, something had to falsify documents and lower one his gun for me to see. I don't know. I'm sure you are familiar with, after watching all my plastered, highly misconstrued, over 30 plus million views just on one site. Where is she going to with 30 plus million views? Interviews, and in which they both repeatedly attempted to feed me their incorrect, incomplete, hypothesized opinion by stating to me everyone has their limits at this seemingly endless point of pers- perpetually perpetually of nonsense and lawlessness still growing. Oh lordy. And I very much want to advance to the next level. Well, we all want you to, Sarah, after ongoing 5 years now. I keep saying 4, but it is 5. You're right. I stand corrected. A genuine concern limit has been reached for all of us, Sarah Boone. Listen, Blaine Boone. See, that's still not catchy. But I thought of a name for you, Blaine Boone. I was thinking like we could like call you BB. BB is much more catchy than Blaine Boone, but I mean BB, that's kind of a fun name. So you don't really deserve that. So I thought maybe Sarah Booby Boone. Sarah Booby Blaine Boone. Sarah Booby Blaine Boone. I thought I liked that. Or I thought Booby Blaine Boone. We could call her BBBB. I don't know. Blaine Boone isn't catchy. Suitcase Sarah fits though. Why am I still not being included in my case? How much more of my case and self? I wanted to say care for a minute there. Case and self is being added hourly, especially after this letter gets loose. Yes, Sarah. You know, I think what's going to send this case over the edge is that you are now going to represent yourself. And I'm sure you're going to bring us a show. Like, Sarah Boone is waiting all her life for this. Like, the curtains are about to go up this fall or this winter. And Sarah will be on stage. And the whole world will be watching because she's going to make sure they're watching. And I cannot wait to be in the courtroom because I will be driving there to Orlando and I will be sitting my happy butt in there watching Sarah Boone. Why am I still not being included in my case? How much more of my case and self is being added hourly, especially after the letter goes loose to the internet, increasing the mass infection and destruction of my hopes to have a fair trial. Anything fair, my side force and anything fair, my side forensics, and wondering how if my attorney drank the punch like everyone. Ooh, a little Jim Jones reference. All aforementioned reasons and so many more for this letter to be written, hoping to deter some of the unfair, one-sided finger pointing of corruption. And hasn't she used all these words already? And real practice being directed at me only by those in the justice system who are trying to deflect the shame and shock from me, from my fearless challenge, the status quo, and it must be so because it's in my face on the computer at the same time on my boob tube television. Brainwash ignorant followers of disbelief. Breathe, Sarah. Community and greed trying unsuccessfully to make my life by character assassination seem worse than theirs, worse than theirs, period. That was a long sentence. No to when anyone else points their finger. Wait. No to when anyone points their finger. One is impolite. Oh Lord. And two, 3 point back at you. Oh Lordy. Hold on a second while I cringe for a moment. Give me a moment to cringe. How something to see. Put the stone down as Sarah, none of us zipped our boyfriends up into a suitcase and passed out. And if any of us had, if I had done that, I would want to be in jail. I would want to be in prison. Oh, anyway, I'm serious. Would any of, oh, I'm getting off track. Okay, anyway. Put the stone down as there will be no casting of anything today. All right. Except maybe for the role of my part for the pre-conclusion documentaries and crystal ball real life stories of true crime incorrectly formulated from everyone supposedly knowing me and judging who they think I am, what really happened and is going to something. Is that futuristically? Looks like futuristically, but I don't know. Remember 3 point back. Oh, we're going back to the hand analogy. Okay. 3 point back. Soothsaying is not a real job. Oh, okay. So you're saying that we're psychics? We're trying to be psychics, or we're trying to tell the all right. To sum it up, oh, she's bringing it home. To sum it up, in the words of my attorney, after I told her to Google me, she stated, there's a lot. To sum it up, in the words of myself, the defendant stated to my attorney after she stated that to me, when can I see? How much longer do I have to wait? Or how many attorneys something be withdrawn for me to be included in my case and be included something than the world presently is. This is my case in every aspect. See all my aforementioned ongoing 5-year questions. I am still waiting for the answers on. Also, I want to make it known I walked out of my attorney in her last meeting due to her snottiness. No. What does that say? Her unwarranted, uninformative, unprofessional, snotty attitude, and her untruthful answer to my questions and beyond. Does she say is that retarded? No, she surely didn't use does that say retarded vicious cycle? The retarded vicious cycle? Oh my God. Oh. We enter, I thought for sure that wasn't the word she used, but she used it. Are we going to find the N word in here? I don't know. Maybe some homophobic jokes. I don't know. Let's see what we find. We enter, every line we meet is a waste of time. And I'm saying that being in jail with supposed endless amounts of how she treats me is extremely prejudiced, hostile, and unconcerned. After you just used that word. All right. All right. All right. She is very frustrating to talk or to balk or defeat in evidence, to induce. Wait. She is very frustrating to balk or defeat in an endeavor to induce feelings of insecurity, discouragement, or dissatisfaction in, to bring to nothing. Is she giving a definition? What is this? So much I presented my solution in order to coexist with and work together in a hopeful, progressive, positive, appreciative, appropriate, I don't know, manner. I added pretend judge to our interactions so she could calm down. Oh, that must have been a lot of fun. Pretend judge. I thought she did it in her mind, but it sounds like she did it out loud. I added pretend judge to our interactions so she could calm down and ease up on her condescending, offensive demeanor and obvious prejudgment. She seems like everyone else not to remember I am innocent until judged otherwise. You did it, Sarah, though. You did it. Okay. She treats me as I am an asshole. Oops. No, sorry. She treats me as if I am not. After something introduction and explanation for with pretend judge in the room or the phone, I am trying to help her understand how she is making herself extremely unwelcoming. Yes, you need a welcoming attitude. I forgot about that, Sarah. You need your arms. You need somebody with their arms wide open. When in front of a real judge and in the courtroom is how she should treat me, her client, at all times. Ooh, yes, because what is it? The customer is always right. Even though you're getting it for free, Sarah, the customer is always right. I should not have to invent pretend judge in order to be and am not at all wrong for wanting to be respected no matter the outcome. I am innocent until judged otherwise. My attorney, everyone should be fair, unbiased, trustworthy, honest, supportive, informative, protective, automatically and effortlessly. Whoa. I should feel secure, highly confident, proud in her representing my life. I do not and have said to her, she's really going in on this lawyer. I think it's because it's a woman. I do not and have said to her many times regarding her. Because what would it have been like if Sarah Boone had got like the tilted lawyer? If the tilted lawyer had, well, is it the tilted lawyer that's handsome? I can't remember. But one of those handsome lawyers had walked in and Sarah Boone would have been like a puddle. I guarantee you a puddle. But eventually she probably would have came around to being a jerk. But anyway, I should feel secure, highly confident, proud in her representing my life. I do not and have said to her many times regarding her something mental disbelief in me and my care, which I believe contributes greatly to her I don't know what that word is. Imbecile? Is that imbecile? Attitude towards me? I don't know. I am hoping by their letter she will pick up the sword of justice and fight alongside, not against me or so many, or so help me God, as so many something overwhelmed, weak attorneys prior who believed our ungracefully as I crept away from the battlefield unsuccessful. I don't even know what I'm saying here. I don't know. I don't know the words that she's writing here. My case, bizarre, unknown, different, arrogance, misunderstood, unfair. This does not mean my case can't equal success, and in more than one way. While everyone continues to ring their bells of she's used the ring the bells before in past letters. A lot of this she's used in her past letters. While everyone continues to ring their bells of misinformation. No, that's not what it says. Malevolence? Is that what it is? I am ringing mine of hope, honor, plausibility, boldness. Listen. Oh, yeah, right. Like, I might have, like, listen. Like, are you saying you're listening? Because you're not a listener, or you're not a listener, my friend. You are not a listener. I am not. Oh, and then she goes on to say, I am not a schmurder. The justice system should equal fair, faith, trust, respect, innocence, and if judged otherwise, 3-point back. What the hell? Is she still are we still 3-point back? Wait, is she no, it doesn't say Blaine Boone. 3-point back. So she's back with the hand analogy. Sarah Booby Boone. Sarah Booby Boone. Love Sarah Booby Boone. Where did I took us somewhere else. Sorry. Let us get back to. So I guess what this page, this letter must be, she must have added stuff to it. I did see some pages of a few maps, and I saw a page of some definitions. So, oh, confused cat meme. Yes, thank you. Hold on, I'm going to cringe again for a minute. Okay, I'm going to take a break and pop over to chat. What do you guys think? Sarah is just that. She's just so special. Sarah Boone is a special woman. Representing my life, you're on trial for the worst crime imaginable. Yeah, she's trying to act like, now is she saying that she didn't do this? This is what I am gathering. Let's see what else she has in here. What do we go on to? Oh, wait. What's this? June 24th, 2024. Video visit. 12 minutes. In addition to my previous letter intended for hand delivery on 6/7/24 at my status hearing, today my attorney made, oh good, we get to hear about all the arguing between, like, isn't it just so weird? Like, not that she is fighting harder with the female attorney. Ugh. Anyway, in addition to my previous letter, I just don't like women that do that to other women just because they're women. Anyway, in addition to my previous letter intended for our hand delivery on 6/7/24 at my status hearing today, my attorney made a video visit to go over everything I've been asking her for and have also sent her, she's got better handwriting here, sent to her personally in 2 letters, 520 to 525, all on the public video visitation box, where on both sides of me, less than 5 inches away from my visit, other inmates were having their visits also. You've probably told them it all, but anyway, I get what you're saying. You're supposed to be in a private space when you talk to your lawyer. That's important. I have explained to my attorney numerous times previously in writing and verbally that despite the noise level, I do not in any way feel comfortable having in-depth private meetings regarding my entire criminal case on the visitation box when where there is no privacy whatsoever and hold an open something with more than 62 other interested all ears inmates. She must be a joy to be with in there. I cannot fully participate, if at all. She's probably got, this is what I envision Sarah in there. She's probably got her little minions that she's directing around, and she probably comes up with other people, but she's been there for 5 years. So Sarah Boone probably thinks she's the head man on the totem pole right now. And that's probably another reason why she doesn't want to leave that jail. I cannot fully participate, if at all, from the entire room, officers included, trying to participate also in my case. As always, my attorney did not listen or care after I repeatedly tried reminding her of my unsecure environment, barking at me, I can listen or not, still going over, speaking, and not at all allowing me to respond. After repeating to her over and over and over, while she's beginning to speak louder and over me, still to please schedule an in-person meeting where all can be discussed further privately with no success of being heard. I disconnected the visit telephonically. She uncooperatively. She is impassible. Isn't it so funny? Isn't it funny that she's saying all this about people? And remember, Sarah Boone, the 3 fingers are pointing back. 3 fingers. Remember? Wasn't there like a movie where there was 3 fingers, but it wasn't the pointing back thing? It was just like you had to put 3 fingers on the table or something. I don't know. Privately, with no success of being heard, I disconnected with the visit. I already read this. See previous letter something her for a copy of the 2 I sent her. I was trying to remedy or listen before sending this to you, Your Honor, and not having to include. Now it's a race to the pulpit. Another race to the pulpit. A lot of repeating. My question, please. More questions. My question, please. Who acts like that and still be able to call themselves professional? I don't know, Sarah. The visitation box. Oops. I gotta go back just a little bit. Shoot, I went back too far. Wait, did I? I lost it. Is there a way to... No. Hold on. I think I'm close. Yes, here it is. My question, please. Oh, who acts like that and still be able to call themselves professional? The visitation box is primarily for family and friends to connect, and if a must from an attorney, reminders, notices, quick questions, not high-level confidential case information. Well, you were probably asking her these questions. Anyway, she, like other former attorneys who always blames their dysfunctions, always, Sarah doesn't have any dysfunctions, on me, said you don't like the answers I give you. What answers? See pages 1, 2, and 3. I am not the problem, except that I want to and should be treated fairly with respect, acting more professional than the paid. Oh my gosh. Did she say acting more professional than the paid? Well, she might as well just put paid help. I've been doing this for over 40 years. Professional after so long and in the experience, common courtesy, customer service, and listening. Customer service, okay. And listening skills should have been acquired. All attorneys, do you remember why you even wanted to be one? Remind yourself. No one listens, and it works in everyone's favor but mine that I am a schmurderer stuck in jail so they can... Wait till you get to prison. Wait till you get to prison, Sarah. Stuck in jail so they can pin one on me. They're uninterested. Oh, did someone sneak in and not let him out of the suitcase or something, Sarah? Stuck in jail so they can pin one on me. They're uninterested, unmotivated, hopeless. They're going to be something. What does that say? Leave me over her haughty attitude. I am not wrong for not thinking less of myself because everyone else has and does. This present attorney foremost. Well, Sarah, I don't think anyone else thinks as highly of you as you think of yourself. No one could ever think as highly as Sarah A+ Boone. Next on the list, attorneys, they keep aimlessly throwing dates for and something, appointing, praying they don't withdraw. Well, nobody's withdrawn until you've written letters to the court saying what jerks they are, or what buffoons, or I forget what you've called her. I mean, you've said so many words. I have not fired any attorneys appointed in my case. Yes, no, you haven't. But you've gone to court calling them buffoons and snotty, and they need to have a welcoming attitude. From me expecting the highest equal standards possible, for wanting the absolute best outcome in my preposterous, mismanaged case. And representing myself is not an option. Oh, yes, it is now, my friend, as both judges have now threatened me with for being outspoken and intelligent in all my observations of the ongoing abuse. I wish there was a way to like move it back like a second. Like, you know how when you're watching on something, there's a way to move it back just a second. Oh wait, no, I don't want to miss the Blaine Boone. We can't let's miss the Blaine Boone. Come back. Jeez. And representing myself is not an option, as both judges have now and another great reason not to have my case meetings on the public visitation box is my personal confidential inmate information, such as my visitation list from 2020 to 2023 with names, etc. My I think people can get that kind of list if they want to. It's not private. New something interactions with inmates and officers, what I eat. Oh, Sarah Boone, that can all be obtained, my friend. What I eat, when, and my personal jail calls also being thrown online. For what? To hate me more, or try to get others to, because I don't eat breakfast, or because I know some Latin have short hair. My penmanship is nice. I don't know, Sarah. I'm having a problem with your penmanship. Or because I'm not getting fat and sleeping all day, but rather fully applying myself. You are gaining a little bit of weight, so just saying. Can't say you're not getting fat when you are gaining a little bit of weight. Has anyone seen what she's been eating? I haven't seen any of her food records, but I would like to see those. Fully applying myself, fighting, still making everyone upset from not having to fabricate something, splice, edit. The world apparently knows all. What's next? How many times I go to the bathroom and what function I perform? No one knows anything, nor seems to want to, from being comfortable in their corruption and sitting to be on top with ratings, webs, lists, and money. My case details, if anyone forgot, and if you think about it, all what keeps getting plastered and plagiarized, posted, and poked fun at about me, it's all in my favor. Ooh, she's going to try to turn this. Let's see how she does it. Proving myself right about all the mindless lemmings, shut-ins, the justice system, advantageously abusing and profiting from everything in my case before my trial and before I've seen. Yeah, Sarah Boone must approve all. Please be sure to read my attachment for prop FRCP. Hold on, I gotta cough real quick. FRCP Rule 3220E, restricting disclosure, and I am the only one who thinks of these things. When can I win? If anything, it's coming. I am not the problem. Oh, you're the problem. If you say you're not the problem 10 times out of not, you are the problem. And if anyone were to slip on my slides, if anyone were to slip on my slides and have experience, is that what that says? I know it doesn't say that. Does it say if anyone were to slip on my slides and have to experience? No, that I don't know what that says. tolerate, deal with any of what I have and am, would bravely be doing the same. Don't knock it till you try it. 3-point back, race to the pulpit, again, always. She seems to like certain things. She's really thinks she's landed on the 3-point back. Again, always Sarah Boone. Okay, so this is where she went into all the definitions that I will not be reading. But you can see them here. I'll read off what she went. Okay, so notice of discovery, she has the definition of that. She has the prosecutor's discovery obligations. She has that on there. Then she has, oh, that continues to be on there. A lot of this is definitions and court law that she put in here. I mean, to the judge, like as if he doesn't know it. And the prosecutor, like they don't know this. And her attorney too. But now she's her attorney. And it just keeps going and going and going until we come to the end. I don't know what's next. Let's find out, shall we? Oh, more. More. Oh, does she have, oh, she has the Florida Constitution in there? We the people? I think she had the United States Constitution up there too. American Declaration of Independence. We hold these truths to be self-evident, that all men are created equal. Yes, in the Florida Constitution. I don't even know the Florida Constitution. We, the people of the state of Florida, being grateful to Almighty God for our constitutional liberty in order to secure its benefits. I'm sure the judge didn't know that either. And I'm sure nobody knew about client attorneys and zealous advocacy and attorney misconduct. And oh, wait. Does she add to the misconduct? Nope. It's just the definition. Sorry. So if you don't know the definition to some of this, here you go. Sarah's got it. She's got you covered. Sarah Boone's got it. She's got it. Let me pop over here while this is just going. I did see too that I saw that there were people doing some Watts case coverage tonight. So I don't think we have as many people tonight as we normally do. Oh, we're getting into the... Why are we getting... I got to go back. I don't know why we're getting... Why is she including maps? Publicity, exploration, and saturation. Oh, she put little stars where she's oversaturated. Looks like she's oversaturated in Canada. Canada, what are you doing? Michigan, Michigan's got it. I'm from Michigan. Florida, Texas, Arizona, Ohio. Who's not covering it? Wyoming, what are you doing? Get on that, please. Who else? Mexico, I'm going to need you to saturate, Sarah Boone. I think Arizona's not doing anything. Oklahoma, we're going to need to see more from you, my friends. Oh, here we're going overseas. I can't see the stars on this one. But she's overseas. She's saturated overseas. Oh wait, let's see. I think she goes after the. I think she's talking again. Let's see. Okay. Publicity, exploitation, and saturation. The United States map. To date, the star is a state where I have received correspondence via mail. Oh, okay. Or messages regarding my current criminal case. World map, page 2. To date, a star is a something where I have received correspondence via mail or message regarding my criminal case. The number grows daily. Most all letters and messages are available for review and understanding of the impact. Most all letters and messages are available for review and understanding of the impact of my care. Details being made readily available on the global internet, creating wrongful ignorance, hate, and massive prejudices before my trial. I, the defendant in my care, have not yet ongoing 5 years fully revealed or even seen all of my case details. Well, you're about to see them all now, Sarah Boone, because you're your own lawyer. Everyone in the world has already had the opportunity to do this, I guess is what she's saying. The continuation of the obvious exploration, always the what I don't know what that's. The waited to keep pressing their incorrect pressure, unfair theories, ideas, accusations, forcibly something I committed criminal acts. You did, you zip Sarah. You know what? Nah, she doesn't even hear it. She doesn't even hear it. You say it and she doesn't hear it. It must be really neat to be that person where people say it to you and you don't even hear it. You don't even hear it. I don't hear that ish. I don't hear it. I just hear my sunshine. My present attorney said it is not necessary to receive a court order. I've been trying to obtain a download my case information to apply from the OCCD tablets. My former attorneys are withdrawing some of my case contents I have supplied to them and which have been deemed lost. Many other items have been returned, not to myself, but to the next attorney, and which have been unable to obtain to date. I am missing numerous case items which I continuously request to be returned or obtained without success. Invasion of privacy, Supreme Court wrongful. Oh, I just must have popped in. She's back with her definitions. My personal individual criminal case is being advantageously exploited and abused from all of my significant life-saving suppressible case details. evidence proof being illegally obtained by coercion. Whose trickery, duress, confusion, and without my permission in any form, written or verbal, to anyone, then broadcasted, distributed, hand delivered to the entire planet. States, countries. Sarah is in hog heaven. She is so happy. States, countries, continents containing all of my potential jurors, causing irreparable, erroneous falseness, tainting my jury pool altogether by forcibly attributing heavy influence, incorrect, in something, motives, theories, ideas. This obvious explanation and invasion of my privacy is creating unnecessary, unlawful, just oppression, something, all my entitled opportunities to be given a fair, proper, successful conclusion of my case. I was prejudged, has already been made unfairly against me from the something violation of my constitutional rights and due process of law as a result of my entire case and personal life being publicly publicized globally before my rightful trial, which lawfully, ethically should be without disadvantage and freedom from all particular deceitfulness and dishonesty made from said evidence exploration. More definitions. We're in the home stretch, I think. I'm a little stuffy tonight. What would we do if we didn't have our little glossary of definitions? Does she have her definitions in here? Unintentional? Do we have the definition of unintentional in here? The judge must have just been looking at this and so annoyed. Coercion, Freedom of Information Act. Are we in the home stretch? I think that might be it. Yes, that was it. Whew. Do I have anyone left here? Oh my gosh. Wow. I'm going to just bounce us right into the next part because I know we are over an hour. So, yes, Sarah Boone has been, after the 8th lawyer, the judge, and he saw this letter, and the judge was like, okay for you.
Presenting herself at trial. There was a last-minute hearing on Friday, and the judge in that case said 8 is enough, granting Boone's former attorney's motion to withdraw and ruling that the defendant has now, on her 8th lost attorney, forfeited her right to counsel because of her ongoing difficulties with all of those other counsel. At a status conference last month, we heard Boone express her frustrations and telling the court why she thinks that things could be going better, saying, quote, she was doing her best.
And I feel that she is untruthful with me and full-blown prejudice against me, which I believe adds to her nasty attitude towards me, and I do not trust her. So I have prepared this for you. It's a letter and an continuation of the letter from the video visit, so you are aware of. And everyone constantly blames me that I am the reason why I am supposedly on attorney number 8, which I am not the reason for any of them. I put this in here also so you are aware. I refuse to be mistreated by her as my attorney. I'm shocked that she has a proposed trial date, considering the fact that I have not seen anything. I keep asking her for just a download of my phone or my medical records or for anything that I've asked pretty much all of the other attorneys as well. All of my questions that I keep asking her are in a letter to you. I didn't know if you would be the one to help me answer them or to spur her to finally answer them to me and hopefully truthfully. I don't know. As I said to you before in the past, you said you were not able to intervene regarding my letters. I still want you to be aware of what it is that I am going through still. And it's a matter of ethics and professionalism with how she should be treating me. I shouldn't have to come up with a pretend judge. Remove her. I'm just trying to ask you, please, forgive me.
We do have this up on our webpage, and as always, we don't watch everything in its entirety or I speed it up. I will put everything in the description. This is for fair play use, and I must use it. This is all my opinion and for educational and surely entertainment purposes only.
To ask you for this. If you could please let her know, please, to just be nice to me.
The defendant, they're calling this a, quote, unique adventure that she's on. Her trial is set to begin on October 7th, where she's going to face charges in the murder of her boyfriend, Jorge Torres. She admits to zipping him up in a suitcase and maintains that his death was an accident after a night of drinking. Still with us, criminal defense attorney Marie Pereira and criminal defense attorney Josh Schiffer. Marie Pereira, based on what you just saw from her inside of the courthouse, thinking back to the pro se defendants that we've had on court TV, what do you expect from this defendant? Do you think we're going to have a lot of antics in the courtroom, something more like Darrell Brooks, or something that might actually sway a jury, like in the Tyrone Tucker Treehouse murder trial?
She seems very articulate and reasonable, but she is kidding right now. She wants a gentle, softer side in her defense attorney, that coming from someone who allegedly watched her boyfriend suffocate in a suitcase while she says, you can't breathe? Maybe you need to shut the bleep up. Really a gentle, softer side. That's hilarious. If it wasn't so tragic, it would be hilarious. Yeah. But she seems very well thought out. It seems like she wants to be wannabe lawyer, and she's telling the woman maybe
I read this today. But some people are saying that she purposely didn't let him out. Like she went upstairs and she purposely left him in there. Like I always assumed she just passed out. Like, do you think she was trying to unalive him on purpose? What do you guys think? Put a 1 if you think yes, she was doing it on purpose, or 2 if she just passed out. I'm a 2, but now I'm thinking about 1. I'm going to be thinking about that from now on.
Strategy that makes no sense. I had a client once who abused his daughters sexually and wanted me to lodge a defense that they were promiscuous, and he thought by abusing them it would calm down their sexual urges. A church man, by the way. This is, people, defendants sometimes think that they can tell you these absurd defenses and you're supposed to just take it. And I think that's what's happening here with her lawyer. It's just tragic, but I don't think she's going to be Darrell Brooks, and I don't think there are going to be antics. And it might even make it worse because she sounds like someone who makes sense, except you don't make any sense right now, sis, at all.
And Josh Schiffer, I know you've said that you don't think she's quite competent, just barely enough to stand trial. Do you think that the judge should or will give her standby counsel? So someone who's not her immediate attorney, but will at least...
Sure, she's going to get standby counsel. I mean, I'm not even a lawyer, and I can probably say yes to that.
Be there at the chair if she needs to consult someone.
I think there's definitely going to be some sort of remedy applied by the judge to protect the integrity of the prosecution. What we've seen is a person refuse to basically work with all of the lawyers. And it's not just been 1 or 2. This has been a revolving door. And at some point that is obstreperous. It is wasteful, and the judge has to put a stop to it, which they've done. Forfeiting your right to counsel is an extraordinary remedy. Remember, you get a right to counsel in the Constitution. So this is a giant issue. I think she's going to rely, just like Marie's talking about, on almost the pity factor.
I think that is what she's going to fall back on when she loses, that she's going to be like, I was forced to represent myself. And in that letter, she was like, she's talking about how she's, doesn't want to be forced to do this. So she just wants to sit in the county jail for the rest of her life. That's all. I thought we could look at this real lawyer reacting to Sarah Boone forced to represent herself, so we could get a little idea on what a real lawyer is talking about. I've never looked at this lawyer, but I mean, 403K is pretty popular. Have you guys watched this, The Lawyer You Know? Hi, Cat's Life. Chris and Heavenly, this is going to be a little bit of a longer one, so if you can't stay, I completely understand. Okay, so let's get into it.
Video I can't wait to do. We are going to read the judge's order forcing Sarah Boone to represent herself. We'll figure out why he did it, why he finally said enough is officially enough. She has forfeited her right to be appointed counsel. Do you know how hard that is to do? She's one of a kind, unlike any other, dealing with a situation like this. And I can promise you, I know this judge, he did not take this lightly. He did not do this flippantly. I have not read this order yet. The first time I'm going to read it is with you. You're going to get my instant reaction, but I can't wait to see what he said and why and how we got here. Let me know what you think in the comments as we go, and if you think he stepped too far too fast, or if you agree with it. So let's get to it. We're going to read this order together. If you guys have not subscribed to our channel and you're following the Sarah Boone case, make sure you subscribe and hit that reminder bell. Check out our Sarah Boone playlist. Motion to withdraw, filed June 11th. We watched that hearing together. We heard what the lawyer said. I said, if I were the judge, I'd say, this is it, Sarah. One shot. And if you get rid of this lawyer, you are choosing to represent yourself. Guess what? He didn't do that. He said he's reviewed the court file. He reviewed the audio transcripts from various hearings. So he's gone back. He's done his research. He's a very smart judge. Having considered the positions offered by counsel Patricia Cashman, having considered the testimony of defendant Sarah Boone, and having considered the positions offered by counsel for the state, the court finds this. Here are the charges on March 23rd, 2020, again, 4+ years ago. The defendant was charged with second-degree murder. Procedural history: on February 22nd, the Office of the Public Defender in and for Orange County was appointed to represent the defendant. On March 9th, the public defender moved to withdraw due to the defendant retaining private counsel, Mauricio Padilla. On March 11th, the order allowing withdrawal was entered, which withdrew from the public defender from further representation. On April 18th, Padilla moved to withdraw due to irreconcilable differences. So the first withdrawal.
Some of these withdrawals were because they worked with them in the other cases, in the domestic cases. And so it was I think like some of the lawyers had represented George or something.
From the public defender, not her fault. Second withdrawal, irreconcilable differences. You could at least argue it's her fault. We don't know specifically what that was, but he said that between him and the defendant, made it impossible for them to continue to effectively represent her. As always, it is difficult to convey all the particulars to the court and at the same time maintain all duties to the client. The motion was served upon the defendant. Defendant confirmed receipt, and he attaches the letter. So he's saying irreconcilable differences. 2 years into representing her, right? Because in March of 2020, the first public defender was out, Padilla was in, and in April, 2 years later, 2022, he was out after 2 years being private counsel. Irreconcilable differences. You can't always say why, but it's a little wink to the court, like it ain't working, judge. At the hearing, Padilla said that he'd been representing her for 2 years. The court advised Padilla that the court had received a letter from the defendant, which seemingly objected to Padilla's withdrawal. The court advised Padilla that the options were to not proceed on Padilla's motion to withdraw or provide the court more about the irreconcilable differences. They want to dig in more to them. Padilla requested an opportunity to amend the motion to withdraw, to prepare and file amended motion with a hearing to be heard. The state advised of Padilla's diligence and representation. The state advised of Padilla's diligence in preparation, and the court commended Padilla's work. Defendant testified to a lack of trust between herself and Padilla. There's going to be a common theme here in this order. But her private chosen counsel couldn't work with her. The state said he did a good job. The court said he did a good job. And the defendant, Sarah Boone, said she doesn't trust him. That was probably her biggest mistake in the case. On May 4th, he filed his amended motion to withdraw, and it said, undersigned's relationship with defendant has become adversarial. Sound familiar? The aforementioned adversarial relationship has interfered with undersigned counsel's ability to effectively represent his client, especially preparing for trial. Undersigned appreciates the court providing him the opportunity to amend his previously filed motion to withdraw. However, after further researching the issue, undersigned is still under the belief that the specifics of the adversarial relationship may disclose information that may prejudice his client, and as such will stand mute on the specifics. So he's saying, if I were to tell you what the major issue was,
I'd have to kill
that
you.
could create an issue for Sarah Boone. We don't want to do that because even though we want to withdraw as her attorney, I don't want to hurt her case. I still want to do what's best for the client. So, respectable. On May 6th, Padilla filed a second amended motion which further supplemented the original. Undersigned
I wish we knew what it was. I really do.
relationship with the defendant has deteriorated to a point where undersigned counsel can no longer give effective aid in the fair representation of Ms. Boone's defense. This motion is in compliance with Florida Rule of Judicial Administration 2.505 F1 and Rule 41.16B. Rules regulating the Florida bar are present, or whether an attorney-client relationship has deteriorated to a point where counsel can no longer give effective aid in their fair presentation of a defense. On May 10, 2022, a hearing was held on Padilla's second motion to withdraw. The defendant was present for the hearing and was sworn. Padilla advised the court that he had no other choice but to file the motion to withdraw due to ethical concerns. The defendant confirmed that she wanted to terminate Padilla as her attorney. The state expressed concern of a strategy to allow the defense attorney after defense attorney to represent the defendant. Okay, so this is way back in May of 2022, after just her second lawyer. A strategy of the defendant being unhappy with every attorney and advised the defendant about the danger of self-representation. The court appointed the public defender, attorney number 3. On June 6th, public defender moved to withdraw due to a conflict. So that's May to June, 1 month, conflict, not her fault. So far we have 1 that is her fault, 2 that are not her fault. We've done this before, by the way. On June 7th, the court allowed the public defender to withdraw and appointed conflict counsel. Okay, that's how we get people outside the public defender's office, because she's conflicted within the public defender's office. I think it was because the victim was also represented by the public defender's office, but I'm not positive of what that conflict was. Either way, we get to attorney number 4. On June 10th, RCC moved to withdraw due to a conflict. Okay, so the regional counsel also moved to withdraw because of a conflict. So attorney number 4, also not her fault. So 1 so far is her fault, 3 are not her fault. On June 22nd, that's an order allowing conflict counsel to withdraw was entered. On July 8th, the consalo moved to withdraw due to a conflict. Okay, so then appointed Mark Consalo. Number 5. Also moved to withdraw because of a conflict. Again, not her fault. 4 not her fault. 1 that is her fault. On July 11th, it was ordered, and Bankowitz was appointed. So Bankowitz, in open court, requested a continuance. Court set a pretrial conference. During the pretrial conference, November 7th, and a trial during the trial period, November 7th. October 25th, the court held a pretrial conference and addressed the court's understanding that a continuance was being sought, and the court's JA was to reach out to the parties. Bankowitz filed another motion to continue. The court entered that certain amended order on the defendant's stipulated motion to continue, which set the pretrial conference for January 17th. On November 22nd, the court set a status hearing on December 20th. On December 19th, Bankowitz moved to withdraw. And we know while all this was happening, she's writing a bunch of letters to the court saying how horrible Bankowitz is. He's not answering his phone. His phone's not even turned on. He's not talking to her. He's not answering her. He's horrible. She needs a better lawyer this whole time. The irreconcilable differences in his motion to withdraw had arisen between the undersigned and his client and his family. And the undersigned will be unable to effectively and properly continue representing the defendant herein. On December 20th, status hearing was held. Bankowitz did not appear due to a car accident. I didn't know it was a car accident. I knew something happened.
Oh, wow. I didn't
Court
know that
reset
either.
for December 22nd. December 22nd, reset the status of the hearing. Bankowitz appeared virtually.
I thought he seemed really frail in the one hearing, and that would make sense because he had a car accident.
Technical issues. Bankowitz was unable to hear the court. The court reset it again to December 27th. We remember when all this was happening. And it was kind of feeding into what Sarah Boone was saying about Bankowitz and some other issues with Bankowitz. The hearing was held on Bankwitz's motion. The defendant was present. The court advised the defendant that the court had received letters from the defendant, which we read. The court conducted a Nelson hearing where the defendant was not seeking to remove Bankowitz. Bankowitz advised the court of the thousands of pages of discovery that he had reviewed and organized in his contact and potential use of and collaboration with expert witnesses, including experts that Padilla utilized, which was attorney number 2. Bankowitz advised the court, by the way, this paragraph right here says to me, the court laying the foundation that Bankowitz actually did do work on the case and didn't just do nothing over the months that he represented her. Bankowitz advised the court of defendant's attempts to call Bankowitz at a rate of 5 to 10 times a day. Bankowitz further advised of his efforts to balance the demands of other clients and the defendant's expectations for communication. In response, the defendant reposited that Bankowitz's representations were untruths, again, calling him a liar. It's always bad to call your lawyer a liar and then say you want him to keep representing you. Raised Bankowitz's prior public reprimands for lack of communication. Alleged Bankowitz's action in this case rose to a similar level and then sought to remove Bankowitz. The court pointed out defendant's inconsistent statements within 10 minutes of them being made and addressed concern over defendant's motivations, especially when there is something defendant disagreed with. The court specifically advised defendant that she is not entitled to an endless line of court-appointed lawyers until you find the one. By the way, this is only the second one that's going to be at least partially her fault. So let's remember that. Endless line. So far, it's been 2. and you don't get a lawyer you
then
personally.
there's the next guy that's going to be a problem. That'll be 3. And then it's the woman, that's 4. And you said the other ones that, the differences could or could not be her problem. So I don't know.
Prefer. The court also explained the circumstances where defendant could represent herself. Ultimately, defendant did not request to remove Bankiewicz. The court denied Bankiewicz's motion to withdraw and directed Bankiewicz to have a conference with the defendant prior to the pretrial conference on January 17th. Case continued several times due to Bankiewicz's attempt to retain an expert through JAC and JAC response, and we knew they were trying to get money for those experts. During this time period, the court had received several letters from the defendant, and he puts all the dates from all the letters from the defendant. Again, we know about those letters. On August 22nd,
I tried to be a legal secretary when I was taking time off from being a social worker because that always burnt me out. I did a few, I tried to do a few other professions when the social work would burn me out. But the time I tried to be the paralegal, I cannot imagine someone calling 5 to 10 times a day and you have to answer it. That would be awful.
Again,
so
withdraw.
busy.
Irreconcilable differences arising between undersigned and the defendant that have made it impossible for undersigned to effectively represent his client. As always, it is difficult to convey all the particulars to the court at the same time, maintain all duties to the client. Again, very similar letters to prior counsel's motion to withdraw. The defendant will not be satisfied with any attorney unless that attorney does not have a caseload and can dedicate his or her time solely to Ms. Boone's case. The best possible avenue is to have the defendant represent herself, as no attorney can satisfy her. That's Bankiewicz's opinion. On September 8th, a hearing was held.
Bankiewicz, what did she call him? The boob, was the soothsayer. He was the first soothsayer out there.
On Bankiewicz's motion to withdraw, the defendant was present for the hearing and was sworn. Bankiewicz addressed the defendant's derogatory statements. She called him a dud and a buffoon and berating behavior. The court advised the defendant that the court had received letters from the defendant. After the court's colloquy of the defendant and her acquiescence to Bankiewicz's withdrawal, the court granted Bankiewicz's motion to withdraw and appointed Winston Hobson. Attorney number 7, but again, 2 were her fault, or at least partially her fault or her choice. 4 were not so far. Now we're on attorney number 7. By the way, Bankiewicz is the only one that we have seen that, if any legitimate concerns arise that he didn't necessarily disagree with, was some of the lack of communication. He said she wanted too much. She said he wasn't giving her any at all. Somewhere in the middle was probably the truth, or where it should have been as far as communication goes. But eventually, after 2 attempts to withdraw, one time Sarah Boone didn't want it, second time she did, Bankiewicz was allowed off the case. Thereafter, the court set a status conference in October, pretrial conference in November. After setting these dates, the court pointed out the deterioration of the working relationship between defendant and Bankiewicz. Court further cautioned that if this becomes a problem on another court-appointed attorney, I'm going to look more closely at what the alleged disputes are. Court further advised that there are certain decisions the attorney gets to make and certain decisions that a defendant gets to make. The court cautioned the defendant that unrealistic expectations regarding court-appointed counsel and reminded the attorney of her right to retain private counsel. So again, we remember back when Winston was appointed, the warnings start to get more serious and stern. On October 30th, status conference was held. Hobson advised as to his conversation with the defendant and setting a status January 2024. Court set a pretrial conference, status as to the readiness for trial. Hobson filed a motion to continue, waiver of presence, and requested a 3-docket continuance, which was like 3 months. Court addressed Hobson's motion to continue, granted it. February, Hobson moved to withdraw. Okay, just a couple months after representing her. Irreconcilable differences, including but not limited to ethical considerations. Very similar issues to Sarah Boone that the 2 prior attorneys that were not just conflicted off had. February 9th, the hearing was held. Hobson addressed a number of issues, asked for the basis of withdrawing, including disagreements on legal strategy, on what can and cannot be done and lack of resources, and the defendant's demands make her difficult to work with, including defendant taking non-viable legal positions and being unreasonable. So now we're getting more specific, but the issues are all dealing with what she expects and what she wants to do and how much communication she wants to have and how much say she wants to have in her legal strategy, especially when it comes to non-viable legal positions, because I think that's something Cashman, attorney number 8, also complained about. As to key substantive defenses, Hobson advised that they retain an undisclosed expert is not keeping with what the defendant has in mind. So the expert isn't agreeing with what the defendant wants either. We see a common theme here.
Oh, we have a problem.
That usually means the defendant says, I want this legal defense, and the lawyer and the expert's like, that's not possible based on the facts and what we have in this case. The court outlined
What do you think she's possibly saying happened now? I mean, like, what is it she's gonna like unload on us? And do you think she's gonna testify? What do you guys think?
Overriding claims for withdrawal by Patia, Bankiewicz, and Hobson, adversarial relationships, lack of satisfaction, inability to meet defendant's desires. The court found that all the defendant's relationships with all the court-appointed counsels have deteriorated such that the defendant and the court-appointed counsel cannot work together. The court advised the defendant that although the defendant has a right to court-appointed counsel, it's not unlimited. The court twice advised the defendant that the defendant may not be provided another court-appointed counsel and that the defendant would have to represent herself if circumstances similar to Hobbs' motion of withdrawal occur. The court further advised the defendant about the dangers of self-representation due to the defendant's lack of legal training and knowledge. So again, we remember this when he advised her of this. And again, to me, that's a scary proposition because you're telling her that's dangerous and it's basically bad for you right before you appoint this attorney Cashman. Defendant never stated that she did not understand that she may not be provided another court-appointed attorney. So we listened to it. We saw it.
We're going to pop forward because we know what happens with Cashman.
Be really interesting. Obviously, it's outside my purview. I'm not a public defender. I'm not conflict counsel. Nobody in my firm is. So it's a little outside our purview to be dealing with these rules, but I'm very interested in it because anything that's novel and new and different is very interesting to me. A defendant in a criminal case can forfeit a right to court-appointed counsel. A forfeiture is an extreme measure that flows from the defendant's abuse or manipulation of the right to counsel and results in the defendant being required to represent himself or herself, even though he has not waived counsel and may still want legal representation. So this is important. We need to pause here for a second and focus on the fact that this is an absolutely extreme measure. We do not want this to become the norm. We do not want people representing themselves. We always warn against it. We always tell how bad it is.
I kind of worry about
and just like we
the people that are starting to represent themselves because they're making it a show, like Daryl Brooks. And I have the feeling that other experts said that she's not going to make it a show, but I don't think it's going to be the show that Daryl Brooks gave us. Not that kind of show where, she's taking off her shirt or anything like that. But, we're going to get a show.
The court warned Sarah Boone before. It's dangerous. You have no legal training. You have no background. You have no experience. Your other lawyers are calling what you want to do in the case non-viable and not legitimate or substantial arguments that you should even be able to make or ever make at trial. So if that's an indication as to how she's going to do representing herself, it's not going to be good. So this is absolutely an extreme and ill-advised measure to forfeit or waive your right to counsel. And it's especially extreme when she doesn't want to waive that right. And she's not choosing to represent herself like somebody like Daryl Brooks, who waived his right and chose to represent himself. Forfeiture is a judicial response that adapts the course of legal proceedings to the defendant's choice to engage in misconduct that undermines the legitimate exercise of the right to counsel. So again, she has to abuse or manipulate the right to counsel. Do you think she's done that? Let me know in the comments. We know she's called her lawyers names, called them duds, said they've told lies. She's made misrepresentations about reviewing certain documents, and then later we see her notes on those documents. She's written letters to the court going outside her relationship with counsel, violating and kind of waiving the privilege that is in fact hers, trying to make them look bad, trying to hurt their careers, publicly doing this, being disrespectful, calling them names, calling them snotty. Is that abuse? And she's figured out by now, every time she gets a new lawyer, it causes delay. Does she want those delays? Is she being manipulative? Is she abusing the process, trying to garner fame and notoriety? Those are legitimate concerns, I think. We'll see what the court says here. As set forth above, the defendant's recalcitrance to the attorneys who are not conflicted out, Padilla, Banquets, Hobbs, and Cashman, so that's 4, antagonism, hostility, and attacks on the professionalism of Padilla over a year after the fact, see footnote 9, of Banquets and of Cashman, and the personal attacks on Padilla, Banquets, and Cashman, each of these attorneys were required to withdraw.
I just saw this. Congratulations, Cat's Life 1 month. Woohoo! A dragonfly for 1 month. And you're a dragonfly of the month.
It has become apparent to the court that the defendant will not permit herself to be represented by anyone. Guess what? That's what Banquet said as well. Additionally, the withdrawal of 8 different attorneys, 7 of which were court appointed, leads to a determination that the defendant has forfeited his right to counsel. I think he means her right to counsel. Under Florida law, the facts at bar amount to a binding forfeiture of the right to counsel. As the court finds, the defendant has forfeited the right to court-appointed counsel. Under Florida law, there is no obligation to conduct a Feretta hearing or to otherwise warn a defendant of the dangers of proceeding pro se. So if you want to know what a Feretta hearing is, go back and watch Daryl Brooks. That's the judge basically over and over again being like, are you sure? Do you really want to do this? Do you know what you're waiving? Once you waive, you can't go back. We're not going to let you have a lawyer go in and out. Are you sure you want to do this? He's like, we don't even have to do that. Her actions have forced my hand. She's forfeited the right to counsel. This is extreme, folks. This is not something a judge does lightly. So let's look into what he says the conduct is that forces this forfeiture and waiver. The court can find a waiver by conduct to the right to counsel. A waiver by conduct requires that a defendant be warned about the consequences of his conduct, including the risks of proceeding pro se. So a lot of these sites are going to say his, because that's what's quoted in the case law, because the defendant was a he in the case, but they can also obviously apply to Sarah Boone. On February 9th, the defendant was twice advised that another court-appointed attorney may not be provided. And that's why, that's one of the only issues I have with all this. I agree with the court. I think there are major issues with Sarah Boone. But I would have been unequivocal in this last-ditch effort to say they will not be provided.
Yeah,
if you blow
he probably should have said
if you piss them off, if you're disrespectful, if you don't agree with their legal strategy, there will not be another. And then I would have given her the very last one. He said that may not be provided, which kind of left the door open. I'm quibbling, though. I understand why and how he got here. The defendant was advised about the dangers of representing herself in May 22. The defendant was advised about the dangers of representing herself again in February of 24. As of February 24, the instant case had been continued 16 times. That's a lot. We talked in Koberger. It's been a year. They're going to try the case in 2 years. That's about average. So 4 years is twice the average. The case has been pending for 4 years, 3 months, and 5 days. That's interesting. Is that a little wink to Sarah Boone, who likes to put the days, hours, minutes, years, months that she's been waiting or that something's happened? I don't know. But I believe this court has read every one of Sarah Boone's letters in this case. I believe he's gone back, watched the prior hearings, read everything to make sure that he does not take this forfeiture lightly in this decision that he has felt that Sarah Boone's actions has forced him into. He doesn't take them lightly. Actions speak louder than words. Another, to me, hit to her letters and the comments she's making. Her actions are more important than those words.
Yeah.
Although defendant's words seemingly reveal a desire to go to trial, because she keeps saying it. I believed her at first. But as time has gone by, even I have started to say, does she like these continuances? Does she like people reading her letters? Does she like where she's at? Does she know she's going to end up there anyways? Does she know she's going to end up with time served? So it doesn't matter how long it takes, because all this is going to be counted toward her sentence. However, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over. Allowing the defendant to her 8th court-appointed attorney, her 9th attorney overall, will only serve to delay the case further and encourage the defendant to persist in efforts to prevent the resolution of the case on its merits, the concept of which was first brought to defendant's attention in May of 2020. So 2 years ago, she was told, this may be the end of the line for you. Then a couple months ago, again, this may not happen again. You may not get another lawyer. Well, the defendant complains that Thankx and Hobson, 2 court-appointed attorneys, failed to meet and communicate, and when the defendant is provided a court-appointed counsel who will meet and communicate Cashman, the ways and means of the meeting and communicating are unacceptable. That's why Cashman was so important. That's why her digging in immediately and getting so much done in a short period of time, meeting with her for 20 hours, reviewing all this, setting depots, getting experts, showing that she's the one. She can deal with this difficult client. Boone still finds an issue. She calls her snotty. That's subjective. Not meeting with Boone, if she could prove that, that would be an objective complaint. A complaint that may be legitimate. I'm not saying it is, but it may be legitimate. And at the time we said, if he's really not answering her calls and never meeting with her, never
Sarah,
talking.
I know she hasn't, but does anyone else like hear snottiness like in every word that comes out of Sarah's mouth? Like it's just like one big snot. The tone is just so snotty. Like sometimes I worry because I don't want to sound like Sarah Boone, but I know like I sometimes enunciate my words like her. I just hope I don't sound like her.
That is not right. That is not justice. That is not zealously representing your client. We can say it's lies. We don't know if it's true. I'm saying if it was true, it was a problem. That's always what I said. If it was true, and if it's not true, I wish you would have pushed back a little bit more. Because it doesn't violate privilege to say I absolutely met with her judge. I talked to her for this long on these different dates. I did pick up the phone. I have logs of when I met with her. But we didn't get any of that. You know who did do that? Cashapp. And this judge very astutely said, some of the legitimate complaints, fine. You're going to find something to complain about everybody, which is proven by Cashman, who did meet with you, but you didn't like the way she met with you or the way she spoke to you. That's proof enough for me, the judge said, that you're going to find a problem. And if I appoint somebody else, it'll be the color of their hair or how quickly they speak to you or how often they call you or show up, or they won't call this witness or that. We haven't even really gotten very far into trial prep. How do you think that would go with Sarah Boone, with one of these lawyers? How do you think she would like them telling her what the strategy is going to be and what the questions are going to be that they ask? So the judge is saying, with how hands-on she's being, how much she's complaining about everybody, the only person that's going to represent her case and do it the way she wants it is her. Ooh, that's not good. Under Florida law, the facts at bar amount to a binding waiver of the right to counsel. So what happens from here and how Sarah Boone acts is going to be very important. We'll talk about that after we read this. All right, what is the order? Cashman's motion to withdraw is granted. As a condition, Cashman shall provide the court an order for costs to obtain transcripts of deposition for the two witnesses Cashman deposed. Upon completion of the transcription of the depositions, the deposition transcripts shall be sent directly to defendant. She wants all her discovery. By golly, she's going to get it now. Thereafter, Cashman shall file a notice with the court reflecting that deposition transcripts were provided to the defendant, Sarah Boone, as such, and such notice shall include the date sent and the address for Sarah Boone. We know where that is. The defendant has forfeited her right to appointed counsel. The defendant has waived by her conduct her right to court-appointed counsel. The trial management conference shall remain specially set for Tuesday, September 24th, 2024. We're pushing ahead to trial, folks. This case shall remain specially set for trial for the 2-week period beginning Monday, October 7th.
Ooh.
My guess is if she really,
October
we'll talk about that after. It will not be continued for any reason except by extraordinarily good cause, and such extraordinarily good cause shall not include retention of counsel by a defendant. So she can still go hire her own lawyer, folks. She can still pay her own private lawyer. That is not going to be stripped from her. Any and all pretrial motion on this case must be filed no later than the close of business on Monday, July 22nd, 2024. And guess what? She'll be at every conference now. She'll be at every hearing now. In the certificate of service, he's going to make sure Sarah Boone gets this.
Sitting up front too, probably.
What does it say? Sarah Boone via hand delivery. This is going to be hand delivered to her. So what does she do now? Let's talk about that for a second. Number one, she can make this very difficult on the court. If she refuses to say anything, refuses to represent herself, refuses to call witnesses, refuses to cross-examine witnesses, and saying, I never waived my right. That puts the judge in a difficult spot. I think I know what the judge will do. I think he'll have colloquies. I think he'll advise her of things on the record. I think he'll give her chances. And her refusal is, again, a waiver. Her refusal to ask questions is a waiver of her right to cross-examine witnesses and confront witnesses. So if she really is difficult, the judge will handle it appropriately. And he'll say it's a waiver. But again, I still think that's difficult to deal with as a judge. But what she can do is dig in, look at the discovery, read everything, watch everything, prepare to cross-examine witnesses. She's got the time. She's told us how smart and intelligent and well-versed she is and well-spoken. She knows how to make an argument. We saw her arguing and trying to convince the cops that she was innocent, and now she'll be able to do it to a jury. So we know she has the capability, at least as a human being, to do it, maybe not as a lawyer. But Sarah Boone, whether she likes it or not, is lawyer number 9. She's lawyer number 9. She's going to take this case on. She's going to represent herself whether she likes it or not. And I do believe that while the court said he will only continue the case for extraordinary circumstances, I think if she digs in, she does her best, she wants to get an expert, she wants to depose a witness. Some people pro se have done that. If she really tries and she tells the court, I need more time, I think the court will give it to her. If she doesn't do anything and she just shows up and asks for a continuance, he's going to deny it, which is crazy to think that this trial could actually happen in October of this year, less than 4 months away, right?
That is crazy.
We've got July, August, September. Yeah, October. This could be happening, folks. And we know we have at least one more hearing in September. What will she be able to get done between now and then? There are going to be all sorts of appellate issues. I will just tell you. Court-appointed appellate counsel that's coming after she loses, because now the chances of her losing are much higher now that she's representing herself. This will be an appellate issue. That's why he very thoroughly went through the record, put everything down in black and white. He says by her fault and manipulation, abuse of the process, these 4 lawyers were out, 4 others conflicted off. So that creates an issue with the public defender's office as well, which limits the amount of lawyers that can really be appointed for her. And now she's going to represent herself. There's no issues with competency. So we don't have that battle like we had in Darrell Brooks, potentially.
She's an A+ student. Of course, there's no issues with that. Okay, well, it looks like, I've got more really quick before we go. Sarah Boone did a GoFundMe for herself. One of my viewers left a comment in my down in my comments. And she said that Sarah Boone had done a GoFundMe. And I was like, what? And she was like, yeah, it went up and it went down. And I was like, oh my gosh. I said, did you save it by chance? And she's like, no, I didn't think that it would go up and it would go down so fast. But I found this. Oh, wait. This, I don't know. Hold on. It won't let me present video or photos. So let me pull the picture up on my computer and then I can do it that way. Okay, hold on. This isn't working. Okay, well, there's a GoFundMe, and I have a photo of it, but I'll just share the the Reddit page. It says Sarah's GoFundMe, and then when you click on it, it takes you to it's been taken down. So it is no more. And it went up and it went down almost as fast. It took like, I don't know, it seemed like just like 4 hours or so for it to go up and for it to go down. Let me see if I can find the photo really quick, because she has, nope, that's not it. Maybe I didn't save it. There's that possibility too, that I didn't save it. Or maybe I put it as a video. Let me try that. Or will you just take my word for it that it went up? And I don't need to be so intense and find it. I don't know. Don't you hate? Oh, wait, here it is.
You know, there's all sorts of publications and
No,
books out there.
that's not it. Never mind. Okay, I can't find it. I'm sorry. And that's all I have, my friends. Thank you, Heavenly and Chrissy, for being my wrenches. Congratulations to Cat's Life for 1 month. Thank you so much, Main Chick, Carrie, my little dragonfly, for donating $1.99. It's really, really appreciated. So I'm gonna go. I want to do some shout outs to my power subscribers of the month of June, which is the Cat's Life. I want to do shout out to my power team. I want to do shout out to all my new and old dragonflies, a shout out to my power replay crew, and a shout out to my beautiful mods. You guys, if nobody's told you this, I'm telling you this. I love you guys so, so much, and I'll see you next time. Bye, guys. Hi, guys. Welcome to Parawomenradio. I'm Amy.
Carefully strumming this old guitar, words rolling out into the fire. Never ask why my heart burned blue. Here in the haze where you inspire me. Here in the darkness I hear my cue. Time to find some solitude. Here where my soul bleeds openly, deep in the heart of sin and you. Here in the blue, I'm falling deep into you. Bye.